Hello to folks on Zoom. I'm just running a minute late today because I grabbed the wrong binder. So I'm just going to go ahead and pull up our lecture and we'll get started. Today we're starting to talk about jury selection, which psychologists are involved in pretty interesting ways. Alrighty. Wow, this is just way brighter than I remember it being. Really wanted to wake myself up when I made that one. Alrighty. Gonna take attendance right quick. And then we will go ahead and get started. Alrighty. Before I dive into our lecture, just want to put in a little plug. As we've been talking about what a forensic psychologist does. Oh, actually, today's preparing for trial. Glad I checked my syllabus. Jeez. Okay. Let me get the other lecture up. But if you're interested at all in what a forensic psychologist does, and you think this is something I might be interested in doing, then in fall, I am teaching a class about assessment. And as you've seen, assessment is a large part of what psychologists do. Ooh, I got a nice echo there. And so that might be a really nice class if you're thinking this is the career path I want to go down. So that is Psych 333. I don't come up with the numbers. And so if you're interested, again, in this career path, or you've just gotten interested in assessment in general, that would be a nice direction to go. Alrighty. And there's plenty of room. Alrighty, so we're actually talking about between arrest and trial today. So, I'm not always on top of things. So thank you all for your patience with me in the midst of me being sometimes a little scatterbrained. So. Okay, so we're going to talk about what happens when you get arrested and sort of that sequence. And then we're going to go on to prosecutions, and we'll talk about some of the ways that folks end up navigating through the criminal justice system that might not be sort of what we stereotypically think of in terms of, you go to trial, you go to prison, that type of thing. All right. So in traditional prosecutions for criminal cases, a lot of criminal cases are simply dismissed for lack of evidence or other difficulties that prosecutors perceive in the case. For the vast majority of people charged with crimes and not fortunate enough to have the charges dropped, they'll end up with plea bargains, not trials, to resolve the case. Plea bargaining is a process by which a defendant agrees to plead guilty in exchange for some concession from the prosecutor. Just a second, just gonna make sure everybody's muted here. Yep, that was just someone outside the window. Okay. So say that again. Plea bargaining is a process in which the defendant agrees to plead guilty. They're going to say, yes, I did this crime in exchange for some concession from the prosecutor. So a reduction in the charge, so maybe from murder to manslaughter, or something along those lines. A reduction in the number of charges if they're being charged with multiple things. Or a reduction in the recommended sentence, right? So if there's a lot of flexibility in what you can be sentenced, 3 to 10 years, and the prosecutor says if you plead guilty, you're only going to get 3 years, people might do that. By pleading guilty, defendants give up their right to a trial because you've said, I did it. We don't need to go through a whole rigmarole to prove that you did it, right? And most civil, so those were criminal cases. Most civil cases are also resolved without a trial in a process called settlement negotiation. Essentially, the lawyers work together. Sometimes there's like a mediator involved. And before you ever have to go to trial, some money is paid out, basically. Alrighty, so if the police suspect that someone committed a crime, they will arrest the suspect. And then they will be charged by the prosecuting attorney, and charging implies a formal decision to continue with the prosecution. And that decision is made by the prosecuting attorney rather than the police. So the police arrest them, and then the prosecutor decides, are we going to charge this person with something, or is there not enough evidence? We're just going to let them go. The initial appearance is a reflection of the Fourth Amendment. So the Fourth Amendment to the US Constitution requires that any person arrested be brought before a judge within 48 hours of their arrest. If the judge reviews the evidence summarized by the prosecutor and determines there is reason to believe the suspect committed the crimes charged, then the process will move forward. But the judge can also decide, doesn't look like we have enough evidence here. The judge will inform the defendant of the charge against them, inform them of their constitutional rights throughout this process, review the issue of bail. So this is where the judge will decide whether or not to set bail and how much bail should be. Bail decisions are determined by a couple things. One tends to be the severity of the crime, and sort of risk assessments, protection of the public, right? If this person's a serial killer and we let them go, they'll probably just kill somebody else. We're not going to give them bail, right? And then also just based on whether or not they're a flight risk. So if this is a person who's well connected and has family or business connections in a country where if they went there, they couldn't be extradited back to the US, they're probably not going to get bail. Now, bail can be offered and also just be so high people can't afford it. That can also happen. And then the judge will at that point also appoint attorneys for any defendants who cannot afford to hire their own attorney. This is where you would get a court-appointed attorney. So what happens after that? Well, if you've been given bail and your family, friends, you can pay it, then you go out to await your trial. You're typically not supposed to leave the city, certainly not the country, right? And you would just sort of wait at home and go about your daily life. If you are denied bail, then you would wait in jail, or you were given bail and you couldn't afford it. You would wait in jail for the preliminary hearing. At the preliminary hearing, the prosecution must offer some evidence on every element of the crime charged. And the judge has to decide whether that evidence is sufficient to pursue the case further. So the initial appearance, we kind of do like a very cursory review. Here we're saying, is this actually going to go to trial? No jury is present during this process, and defendants rarely testify or offer any evidence of their own. It would be the attorneys. The judge will sometimes send this case to a grand jury or reduce the charges because the judge believes the evidence does not support the level of crime charged by the prosecutor, or because of some sort of plea bargain. So you can have a plea bargain where you plead guilty, or you can have one where you're kind of talking about lesser charges. So the grand jury, you just heard me mention that. What does that mean? So the grand jury consists of citizens drawn from the community. They meet in private with the prosecutor to investigate the criminal activity, and they return indictments. Indictments are complaints prepared by the prosecutor describing the crime charged. The grand jury can call witnesses if it is dissatisfied with the witnesses presented by the prosecutor. So they could be like, yeah, these people all just seem to be one-sided. When you describe this, you also mentioned Joe Schmo being there. Let's get Joe Schmo in here, right? In some states, the defendant does have the right to testify during the grand jury process. And in about a third of states, a criminal defendant cannot be prosecuted unless a grand jury has found grounds to do so. The remaining states permit the prosecutor to proceed either by grand jury indictment or by a preliminary hearing. If a grand jury decides there's sufficient evidence to justify the defendant being tried, it issues an indictment. And again, remember that an indictment is complaints prepared by the prosecutor describing the crime charged. And when the grand jury issues them, they sort of say, yes, this is at least enough evidence to go investigate these further during a trial. Then there is the arraignment. At the arraignment, the judge makes sure that the defendant has their attorney now. You've either gotten your own or you have the court-appointed one. And the defendant is asked to plead guilty or not guilty. It's customary for defendants to plead not guilty at this time in order to provide opportunities both for discovery and for plea bargaining. So discovery is where the defendant's attorney can review some of the evidence against the defendant. The process of discovery can also include interviewing witnesses as well. Okay, so we've done all that. That's a lot of stuff already, right? But what happens before you even get to the trial? Defendants and their attorneys want to be aware of the evidence the prosecution will use to try to prove its case. So in civil cases, each side is entitled to discovery. Each side can question the other's witnesses and review documents that the other side might use at the trial. So in civil cases, essentially everything that's going to be entered into the trial, whether it's someone talking or some sort of documentation, both sides can look at it. In criminal cases, what the prosecution must reveal to the defense varies. Most states require that the prosecutor only has to share evidence that's exculpatory. And exculpatory means that tends to show the defendant is not guilty or suggests the prosecution witnesses are not credible. In many states, the defense is required to notify the prosecution if it intends to rely on any sort of insanity defense or any kind of alibi defense. So if you're going to go in and say, there's no way I could do this because I was at work at the time and 50 people saw me there, you've got to let the prosecutor know so that they can verify that. During the discovery process of the case, both sides file pretrial motions seeking favorable rulings on the admissions of evidence. So they might motion to have separate trials for separate charges, motion to sever counts, motion for a change of venue. So often this would be This case is really heating up in the media in this county. We should change it to someplace where the jury will be more objective. Motion to suppress a confession or other statement by the defendant. And then motions in limine, which is a request for a pretrial ruling, basically saying like, let's decide on this before we even get to the courtroom. So the process of discovery, as you can imagine, with all these different motions and all the various ways you're getting information, can take months, right? And so, and each time you go to court for one of these motions to be considered, that pushes back the trial date even further. All right, so backing up a little bit to talk a little bit more about bail. So when they're deciding whether or not to even set bail, judges must decide whether to keep criminal defendants in custody between arrest and trial, or whether to release them with a promise to reappear for later hearings. So judges can just simply deny bail. No bail is issued. They cannot go out. And again, this would be often if the defendant is seen as a flight risk and or a danger to the community. They can require that money be deposited with the courts, and this is where bail bondsmen often come into play. And so oftentimes what happens with the bail bondsman is you will pay them a percentage, something like 10% of the bail, and then they will pony up the rest, basically, and then you're responsible for sort of paying them off over time. That also means, however, that if you miss your court date, the bail bondsman will track you down and take you to court because they want to get their money back, right? So you are potentially involving someone else who makes sure you're part of that process. I think bail bondsmen make really good money. There's one in my neighborhood. How do I know? Because all of his vehicles are wrapped with bail bondsman stuff. And every couple of years, he gets a new vehicle, like a Hummer or something that's wrapped in bail bondsman stuff. And he lives in the big houses in the back of my neighborhood. So I think they do okay for themselves. That's a career anyone's interested in. They can also require that a third person be responsible for the defendant's future appearances. And that person would forfeit their money if the defendant doesn't appear. So this would be where like someone's spouse or parents or something would say, I'll make sure they get there, I'll put up the money. Unfortunately, sometimes this results in, like, let's say someone's elderly parents using their home as collateral, and then the person doesn't show up. It's very problematic, right? But people will do a lot of different things to try to protect their family. In addition to ensuring that defendants return to court, bail has a secondary purpose, which again is protecting public safety. So bail decisions are determined both by legal and extra legal factors. So legal factors are things like how serious the offense is. Research has shown that bail is likely to be denied or set very high when the offense was serious, and also when the defendant has prior convictions. Extra legal factors include things like the defendant's gender or race. And again, these should not make an impact, but they do, because the people making these decisions are people, and people have biases. So race and gender have been shown to have significant impacts on judges' pretrial release decisions. So defendants of color are less likely than other defendants to be released, in particular Black defendants. And female defendants are typically assigned lower bail amounts than male defendants. No, is any of that right? No. Right? I mean, you could certainly have, a female serial killer, and they are documented in history and just as dangerous as male serial killers, right? But it has to do with the biases we have inherent in our society. Judges tend to use a mental shortcut called the matching heuristic when determining whether bail should be allowed. They search through a subset of available case information and then make a decision on the basis of only a small number of factors. So things like offense severity, prior record. However, this means that they often ignore other seemingly relevant information. So example, you have someone who doesn't have any priors, but they committed a pretty violent crime, right? You should probably take that into account, but sometimes people don't necessarily. Does pretrial release, whether or not you get bail posted, affect trial outcomes? Yeah, it does. Defendants who are detained in jail are more likely to plead guilty. Basically, they just want to get out of jail. So they're like, yeah, I did it. It's fine. Get me home or get me to the next step. Defendants who are detained in jail are also more likely to be convicted, and they also receive longer sentences than those who can afford bail, even when the seriousness of their offenses and the evidence against them are the same. Now, there's a couple different reasons for this. And I think the primary one is not that bail itself determines these things, but it's a step back in that people who can afford to post their bail or who have lawyers who can convince the judge to allow them to get bail are often people who are better off economically, right? People who can afford the fancy lawyers, people who can pony up $50,000 if that's their bail. And so richer people in general tend to have shorter sentences, slaps on the wrist, things along those lines. So for example, unfortunately, there's a lot of evidence to show that people of color who abuse drugs get much more severe sentences than especially rich white individuals who do the same thing. Does it, okay, we did talk about, does it affect the outcome? The question then becomes, are we any good at this? Can we actually identify who's high risk? Around 1970, a push began for legislation that would increase the use of preventative detention, and that's what it says in the red down here. It's supposed to be on the white. Not really sure what happened with the formatting. But preventative detention is the detention of accused persons who pose a risk of flight or dangerousness. This whole idea assumes that valid assessments of risk and accurate predictions of future dangerousness can be made. And as we've talked about previously, clinicians do their darndest. They're not necessarily great at it. And judges might not even necessarily be great at it, to be perfectly honest. So that's something that we need to be aware of as well. Now, another thing that we kind of need to keep on our radar is the whole idea of pretrial publicity. So particularly when cases involve someone famous or cases are very dramatic, we have folks who get covered on the news a lot, right? Think about, I mean, this is a civil suit, right? But think about the Gwyneth Paltrow trial, right? If it was anybody else who ran into anybody else on the ski hill, no one would care. No one would be talking about it, right? And yet, if you just Google Gwyneth Paltrow right now, you're going to find a whole host of information about this kind of petty lawsuit where they're like, you ran into me. No, you ran into ski on a ski slope. And so all of those things might affect the jury if there is a jury involved. And so, sorry, I'm just trying to find my notes about this in particular. So give me just a sec to skip forward here. There we go. Okay, got it. All right, so we have a couple different issues that arise here. One is conflicting rights. We know the First Amendment, this is one of the ones people love to tote, right? Allows people to inform the public about criminal investigations, particularly it covers freedom of the press, right? So it's not illegal for the media to cover these things. However, the Sixth Amendment concerns the right to a speedy public trial before an impartial jury. So sometimes the rights of the media / the public and the rights of the accused can be in conflict, right? So they clash when the press publishes information that threatens a defendant's right to trial by impartial jurors. A common problem that occurs when the local media and of course now internet sources, everybody on TikTok has an opinion about everything, right? Is that they can disseminate information that's not accurate, right? It's based just on hearsay or a couple of the facts. They can disseminate prejudicial information, like a defendant's prior criminal history, which may or may not be actually allowed to be brought up during the trial, depending. And what we know is that it is exceedingly difficult to disregard previously acquired information. So if you hear something, again, on the news, scrolling through social media, and then you're selected for a jury, and they tell you, pretend you don't know anything that you've heard already. People are not good at that. It's in our brains already. It's kind of like if I tell you, don't think about pink elephants. Probably every single one of you is envisioning a pink elephant right now, right? And so it's basically, once you see it, once you hear it, you can't unsee or unhear it. So what are the legal rulings related to this? Because this obviously can be a big issue. So in Rideau v. Louisiana in 1963, the court decided that exposure to news information strongly pointing to the defendant's guilt was a violation of due process. And so this is why sometimes during trials they'll like sequester jurors, and they're not supposed to have access to TV and things along those lines. The Nebraska Press Association v. Stewart in 1976, the court ruled that the trial judge could not order the press to refrain from publishing information likely to be prejudicial to a defendant. So the judge can't issue a gag order unless the defendant would otherwise be denied a fair trial. So the idea is if it's just sort of like hearsay that's not directly linked to the trial, but might like just make the defendant look like a bad person, whatever. But if it's actual evidence, it's going to be presented in the trial and it's being presented inaccurately, the judge can issue a gag order related to that. In Richmond Newspapers, Inc. v. Virginia, oh, hey, close to home. In 1980, the decision said the press cannot be barred from attending and reporting a trial because the First Amendment guarantees public access to criminal trials. Now, that does not mean full access in whatever way they want. Sort of each court, and depending on their jurisdiction and laws and guidelines in their jurisdiction, can decide what that means. So some courts will allow TV cameras in, but for example, the Supreme Court doesn't. They do audio recordings, but no video recordings. So I don't know if anyone else watches Last Week Tonight with John Oliver. Highly recommend. A few years back, he was like trying to figure out how to get people more invested in Supreme Court cases. And he thought one of the problems was there's no visual representation, right? You're just hearing these audio files. And so he created this footage of little dogs, like actual dogs representing the justices. So like RBG's was this little tiny dog because she was tiny. And he was like, everybody use this. I don't think anyone ended up using it. But you know, it can create some barriers to people being engaged, right? This is also why there'll be like sketch artists in certain courtrooms that don't allow cameras. In Gannett Co. v. DePasquale in 1979, the press can be excluded from pretrial hearings in which potentially prejudicial material might be an issue. So it's basically, you don't have to let the press be at the arraignment and all these other pretrial like motions. And then Moomin v. Virginia in 1991, the court held that defendants do not have a constitutional right to ask prospective jurors about the specifics of their exposure to pretrial publicity. So that will come up more next week when we do start talking about jury selection. All right, so what are the effects? Why do we care, right? Why are we spending so much time hemming and hawing about this? Why are there so many cases about this? Well, one of the things that psychologists and other social scientists like criminologists do is to study this, to study the effects of pretrial publicity, what happens. And we can do this in a couple different ways. One is experimental studies. So in these particular studies, we would create sort of simulated jurors for a case, and participants would first be exposed in the experimental group or not exposed in the control group to some form of publicity, and then asked to assume the role of a juror in that trial. And then researchers measured the impact of getting exposure to the publicity on decision making. So you have two groups of people who are not actually jurors, but they're asked to play that role. One group gets exposed to the media, one group does not. And what they found from these studies are a whole host of things. So in general, pretrial publicity has been found to affect jurors' evaluations of things like the defendant's character, the extent to which they like or sympathize with the defendant, their pretrial thoughts about their guilt, and also their final verdicts, which is, of course, the most distressing one, right? Because again, that's supposed to be objective. So why are they affected in this way? Pretrial publicity may bias jurors' interpretations of the evidence presented at the trial. Again, once you have something in your head, you can't ignore it. And so you'll start to see everything through that lens, right? Also, jurors can believe wrongly that the pretrial information was actually presented as evidence at the trial. And this is called a source monitoring error, where they're like, yeah, you know, this information that was at the trial. And people will be like, what? No, the other jurors will be like, no, that was never presented. And they realize, oh, I heard it beforehand. Presentation of publicity via television, and I would guess other video-based media, again, like YouTube, TikTok, things along those lines, have been found to have greater biasing impacts than the same information presented in print, say like more like a blog style, Twitter, or a newspaper. But the combined effects of TV and newspaper publicity had the greatest impact of all. Participants are generally unaware that their opinions have been biased by this material. This does not surprise me at all, just given that people in general are generally unaware of our own biases that we hold. Right, and when you start examining them, it can be very difficult to realize, like, I hold a weird bias about that. Give you an example, there is a really interesting test you can do called an implicit attitudes test. And it was initially created to look at race-based attitudes, but you can also do them based on a whole host of things. So one of my female professors in college who was in cognition, so she was our equivalent of Dr. Ariel, which is sort of an even more sciencey part of this, like the science of psychology, right? Took an IAT and realized she was biased against women in the sciences. And she was like, what? She essentially had like internalized misogyny she didn't know about. It was really hard for her to come to terms with that and then start addressing that. So people are not good in general about realizing what biases they have. So that was all about like general pretrial publicity. Now specific pretrial publicity, very case-specific information made available prior to the trial can really affect the sentiments of the jurors during that trial. But mock jurors can also be swayed, influenced by, and again, it's down in the red, generic prejudice is what it says down there, generic prejudice, which is prejudice arising from media coverage of issues not specifically related to a particular case, but thematically relevant to the issues at hand. So these can include things like prison reform, racial and ethnic stereotypes, those people. Nothing makes me want to like gag more when someone phrases it that way. So that can influence people as well. The other type of study you can do is called a field study. And in field studies, respondents are surveyed to assess the effects of publicity about a particular real life case. So most of the time when you're doing an experiment, it's just sort of in general knowledge, science related to these decision making. But in field studies, they are like, okay, let's see how the media is influencing this particular case and how people are thinking about it. So they'll poll people exposed to actual reports of actual crimes. And researchers have found that persons exposed to pretrial publicity possess more knowledge about the events in question. That makes sense, right? They've just gotten more information about it. Are more likely to have prejudged the case. So they think they already know whether the person's innocent or guilty before they would ever hear the evidence presented in court. And are more knowledgeable about incriminating facts that would be inadmissible at the trial. So again, in some cases, someone's previous criminal history is not admissible at a trial, depending. But the news might talk about that, and the person already has that in their head. Both types of studies, both experimental studies and field studies, reveal that jurors may be adversely affected by pretrial publicity. But again, it's the First Amendment. We're not going to stop it. This is just something you have to know. And also why people might ask for like a change of venue, especially if it's like a local case that's only getting publicity locally, then changing to like another county to try it might eliminate a lot of this. Now, in terms of pretrial publicity, what are some of the remedies? One is a continuance, and a continuance is where you postpone the trial. The idea here is that you're just sort of hoping all the media hype dies out, like people get bored when they're waiting around. You can expand voir dire. We'll talk about voir dire next week, but this is part of the process of juror selection. Where you rule jurors out based on a whole host of factors. And in this case, it might be how much coverage have you heard or how biased do they seem to be already. This tends to be the most popular method, just being much more careful in jury selection. Sometimes there will be specific instructions from the judge to the jury. This has been covered a lot in the media. We need to really focus in on what's being presented here. Not surprisingly, that particular technique is largely ineffective, but also continuance and expanding voir dire are also not that effective. Again, even if a case gets delayed a year, if someone heard something before already about the case, it's not going to magically disappear from their brain, right? So what social scientists prefer is a change of venue. So that's really the only way to make sure you have a clean slate that's actually going to address these issues. Wow, that turned out really small. Okay. So plea bargaining in criminal cases. So 90 to 95%, which is what the top one says, I swear. Most criminal cases end prior to trial with a plea bargain. So that means only 5 to 10% of criminal cases actually go to trial. The defendant pleads guilty to some charge in exchange for some concession from the prosecutor, like a reduction in the type of charge or a reduction in the recommended sentence. In change bargaining, the prosecutor drops some charges in return for a guilty plea. And what's really interesting is that because they know this is the possibility, prosecutors will sometimes overcharge people, add on charges that are valid, but they typically wouldn't charge the person with. Plea bargaining can also take the form of sentence bargaining, in which prosecutors recommend reduced sentences in return for guilty pleas. So the prosecutor is not the one who decides the sentence. It's typically a judge or a jury, and if we're doing a plea bargain, it's going to be a judge. But in general, judges will follow the sentence recommendations by the prosecutor. So this does have an impact. If the prosecutor says, I recommend, only 3 years instead of 10 years for this person. So why do defendants plead guilty? Number one is when they just know they're going to get convicted if it comes to court. So sort of like, why spend all those legal fees and all that time and all that energy? Just get it over with. And another reason they might plead guilty is that because if they are convicted, they would face lengthy sentences. So sometimes there's more flexibility on the part of the judge if the person hasn't officially been through the trial in terms of minimum sentencing. Okay, that makes sense for defendants, but why would prosecutors plea bargain? Don't they want to get people on like the highest charges possible? Well, one reason is to dispose of cases in which the evidence against the defendant is weak or the defense attorney is a formidable foe. They run into this person in court, they know it might mean they might lose. So they have a motivation basically to cover their own butt by having someone plead instead of going to trial. It basically ensures a win. Sometimes they'll do a plea bargain when there's multiple defendants in a crime. And they'll do that to get the testimony of one defendant against a more culpable defendant. So let's say it's armed robbery. The person you're doing the plea deal with only drove the getaway car. But you want to get the person who actually like wielded the gun in the bank, right? You might get into a plea bargain to get that person to testify against the person with the gun. Also, just to expedite the flow of cases. Even though, again, not most are going to trial, prosecutors deal with a lot of cases. And so the idea of just like, okay, if we can get this one done in like a couple weeks with the plea bargain instead of several months with a full trial, let's clear that one off of our slate. So there are psychological influences on the plea bargaining process. Again, not surprisingly, we know psychology affects a whole host of things. The first is framing effects, and this is the way decision alternatives are framed. So if you present them like, well, if you plea bargain, this will happen, and that's great. You present it as a gain. Then the person's going to decide differently than if you present it as a loss. Right? Like, well, if you plea bargain, then you'll have to go to jail, just not for as long, right? So that can have an impact on a person's choice. Individuals are more willing to take chances when the decision alternatives are presented in terms of gains rather than in terms of losses. There's also what's called the overconfidence bias, where people tend to be too optimistic about their chances of securing favorable outcomes. So that could go a couple ways here. Right, if they think the plea bargain is really going to go well for them, they might do that. Or you might have someone who's like, no, when we go to court, I'm going to really determine this. It's going to be great. And sometimes that blows up in people's faces. So in general, how do people feel about the idea of plea bargaining? Advocates of plea bargaining cite the following justifications for using plea bargaining. The guilty pleas relieve the backlog of cases, making everybody else's cases go more quickly, more efficiently. That serves justice in its own way. And that allows you to facilitate the prosecution of others, not only by freeing up the cases, but again, also if you can get that person to testify against someone who did something more wrong. And also the absence of a trial reduces the involvement of various criminal justice personnel. That saves money, time in the long run. Critics of plea bargaining cite the following justifications for why this maybe isn't great. One is improper sentences. So a lot of times, again, we're using more of a minimum sentence. And so people are like, that's too lenient. But sometimes, again, especially if you have a naive defendant who has just like a public defender, they'll end up with more harsh penalty than if they'd gone through trial. The process encourages defendants to surrender their constitutional rights. If you say, yeah, I did it, right? Then you're kind of giving up your right to a trial and your own involvement. Some people argue that plea bargains give too much power to prosecutors. And Probably the biggest one is that people who are innocent may feel coerced to plead guilty just to sort of like get it over and done with. And that's obviously probably the biggest issue, because we do not want to be punishing people who did not actually do the crime. But again, people will just do it to get back to their lives. Okay, so that was all criminal cases. And so now we're going to start talking about civil cases. So as I mentioned previously, the vast majority of civil disputes are resolved without a trial through settlement negotiation. Typically in private negotiations between attorneys representing the disputing parties. The legal merits of the case are what matter most here, but outcomes are also influenced by the negotiator's reservation price. And so the defendant's reservation price is the maximum amount of money that they would be willing to pay to reach an agreement. And the plaintiff's reservation price is the minimum amount of money that they would accept to settle the claim. And this is why people need to like really do their research, because plaintiffs can sell themselves short, right? And be like, oh, I don't know, $10,000. And you know, the company was willing to give you $1 million. So they're like, sold, right? They're not going to tell you they were going to pay you $1 million, right? So having a good lawyer who can give you those benchmarks or researching other cases can be really important. In addition to considering the merits of the case, plaintiffs, defendants, and attorneys are also influenced by heuristics, psychological biases. So the self-serving bias occurs when people interpret information or make decisions in ways that are consistent with their own interests rather than in an objective fashion. So parties will have difficulty seeing the argument or the merits of the other side. And then the anchoring and adjustment bias occurs when negotiators are strongly influenced or anchored by an initial starting value and do not sufficiently adjust their judgments away from that starting point. So again, this is why as a plaintiff, you need to come up with a good high starting value, right? Because the higher the initial starting value in negotiation, the higher the ultimate settlement, the more money you get. Okay, so this has all been, okay, what will happen if we don't actually go to trial? But of course, cases do, again, maybe 5 to 10% in criminal cases. So why do we have trials? What the heck is the purpose of a trial? So Miller and Bolster wrote about this in 1977. And they have identified 3 different ideals even, we could probably call them, about why we engage in trials. One is the trial as the search for truth. So this assumes that the truth can be ascertained and that it will emerge from the trial. It'll emerge from the confrontation of conflicting facts. It also assumes that judges or jurors can put aside their prejudice and decide the case with a dispassionate analysis of the arguments and the evidence. And maybe not surprisingly, given everything we just talked about in terms of biases and heuristics, this can be really difficult to meet this ideal. But this is one of the ideals in terms of what do we want trials to do. A next possibility is the trial as a test of credibility. So this acknowledges the facts, or acknowledges that facts and evidence are incomplete and biased. Judges or juries must weigh and evaluate the truthfulness of these opposing sources. Unfortunately, both judges and jurors can make unwarranted inferences. So this is fully acknowledging we might not get to the truth, but at least we can try to figure out whether something's credible or not. And then there is the trial as a conflict resolving ritual. This provides a mechanism to resolve controversies, to create the sense that justice is being done. Okay. Right, I would say in a lot of cases, we don't necessarily hit on any of these three, right, but at least we kind of get to parts of them. Alrighty. I'm kind of looking over my notes here. And I think what we probably want to do is stop there for today, just because I have a panel I have to do at noon, and I have to get over there a little early to set up, and also that will allow us to talk about these steps all at once. If any of you are not psych majors and you're interested in finding out more, we have a panel at noon in the Lighthouse talking about that, just that. So